Hey everybody, welcome to our video. We'll look at a recent case from the Sixth Circuit Court of Appeals called Huff versus Telecheck Services. And I want us to look at this for a couple reasons. One, it'll describe how this credit reporting agency, Telecheck Services, works. And then we'll look at, has the plaintiff, this person named Huff, have they shown that they have standing to be in federal court? And you'll see that the majority opinion, so a federal appellate court typically has 3 judges. 2 of the judges say absolutely not, has not done enough to show that he has standing to be in federal court. This is after all discovery has taken place. This is at the motion for summary judgment stage in this class action case. And then you have the dissenting judge say absolutely he has shown enough. And it's a good illustration for why sometimes when we as lawyers are asked questions and we go, well, it depends. And people go, why do you have to say it depends? Just tell me yes or no. Well, a lot of times it's because maybe in this part of the country, the judges tend to say one way, or this other part of the country a different way. But here, even in the same part of the country, a case arising out of Tennessee, you've got 2 judges saying it's absolutely clear. And then you've got one judge saying it's absolutely not clear that he should be thrown out. So I just want you to see that, and I think this will be the first case that at least I've looked at that has what we call a dissenting opinion. So the judges are split. You can think of it like a boxing match where it's a split decision, right? 2 judges rule for Smith and 1 judge rules for Jones. Same type of thing here. So let's look at this case, and it is a little bit lengthy, but I think it'll be worthwhile to look at this. And you'll also see that the judge who wrote the opinion, the Sutton judge, has kind of a conversational approach here. And so, again, different judges have different approaches here. So you can tell this is going to be a little bit different when it starts off, deals with fading technology checks and an evergreen imperative, Article 3 standing. So again, it's not going to be your just normal opinion here. And the court says when you buy something with a check, merchants often consult a check verification company. And so this guy requested a copy of his file from Telecheck, and it omitted that his driver's license was linked to 6 different bank accounts. And so he files suit, and the court says, you haven't shown that an incomplete report injured you in any way, so we affirm or we agree with the district court's dismissal of the case for lack of standing. So let's get a little bit of background here. And if you've never known how a company like Telecheck works, this gives us a pretty good explanation of it. So a retail consumer offers a check. The customer provides usually like a driver's license, and then the merchant sends that to a company like Telecheck, and then Telecheck runs that identifier, that would be the account number on the check, the driver's license. It runs each identifier through its system. And so if one of those identifiers has a debt on file, then you get a code 4. So that's a negative decline. But what if there is not a debt on file? Well, then they look at the check writing history to determine whether to send a code 3, and that would be a risk-based decline. So if there's a debt on file, and we're not talking about like a credit card debt, but a check that was not paid, that's a code 4. If there's bad check writing history, that would be code 3. And here we get the summary. Telecheck recommends a decline. It refuses a check if there's no debts on file and it's a low risk. Telecheck approves transaction. Merchant accepts the check. So what happens when you have 2 identifiers? Well, then Telecheck records a link between those. So they say, okay, here's your driver's license and here's this account number. So now we're going to form a link between those 2 items. And then it says if in a later transaction only uses one of the identifiers, there's a code 4 decline if the debt associated with the presented identifier or the linked identifier. So here's an example that the court's going to give us. You do your driver's license with a check to buy milk. So now that will link your driver's license, and the account number. And then you bounce a check on the same account. So, you used your Bank of America account, write a check, and then you bounce it. Now, when you try and buy eggs with the check from a different account and present your license, Telecheck will see the identifier linked to the license. The bad bank account shows the debt, and there's a code 4 decline. And then it says for a code 3 decline, linked identifiers play no role. So why in the world are we talking about all this? Because this plaintiff pays by check. He saw an advertisement from legal services, and so he decided to request his file, which you can do. You can do for free. Get your Telecheck file. And it says he provided Telecheck with only his driver's license, and so the report contained 23 transactions in which he presented his driver's license last year, but it told him they had more information. And they say, look, there's additional information. We need to verify your identity. Call us. He didn't call. Instead, he sues. Well, why does he sue? Well, his driver's license is linked to 6 different accounts. His own account, his wife's account, 4 accounts hadn't used in years. And they were linked because he had presented his license and transactions along with checks from those accounts. And then the report did not reveal 2 checks from over the past couple years where he did not use his license. And this is important for the court because they say Telecheck has never told a merchant to decline one of his checks. So they do discovery. That's things like depositions, interrogatories, requests for production. He moves for class certification, which is saying, Judge, I want you to appoint me as the class representative for everybody in the same situation. Well, what would be the same situation? That has requested their credit report from Telecheck and not received their full report. Well, Telecheck moves for summary judgment. And that's where you say, looking at the facts and giving Huff here, the plaintiff, the benefit of the doubt, no reasonable juror could find against us. And they said, we're making this argument based on a lack of standing. So they're saying to the judge, since we wouldn't have the jury decide this, it's saying, look, Judge, give every benefit of the doubt to Huff if there's some factual conflict, but you have to rule that there is no standing, and thus he gets kicked out of federal court. And that's exactly what the judge did. So if you've seen our other videos, you know this comes up in virtually every federal court case, at least where you don't file it in state court to begin with. And I've been harping on this for years, and lawyers have sort of been critical of me when I bring this up in CLEs where I'm training other lawyers. They say, well, that's silly, that's stupid, you don't have to do that. This is why. This Article 3 argument that you lack standing is just out of control. And in this case, we see the entire lawsuit is lost because of this. So this will go a little bit deep into some constitutional things, but I think it'll make sense. So Article 3 limits the powers of federal court to cases and controversies. And what this means is we don't offer advisory opinions in federal court. We don't say, well, this is what, this hasn't really happened, but if this was presented to me, this is how I would rule. Courts say, no, we don't do that. So instead, limitation checks the power of the judicial branch by confining it to resolving concrete disputes. And it checks the powers of the legislative branch by prohibiting it from using the judiciary as an adjunct to its own powers. And so we have this concept of separation of powers. So the executive branch, think of the president, he's got his powers, but he's not above Congress, and Congress is not above the courts. And so you have these 3 powers that can balance out each other. And so we find out Constitution makes standing an indispensable ingredient. So to show standing, there are 3 things. And almost always in these cases, we're really just talking about the first element. So number one, suffered an injury. Number two, caused by telecheck. Number three, that a judicial decision could redress. In other words, this lawsuit can make a difference. And so the burden of establishing standing rests with Huff, and he must provide the allegations or evidence at each stage. At the motion to dismiss stage, where we have no discovery, then you can rest on your allegations. But at the summary judgment stage, you have to actually provide evidence. And that's what the court says here. Summary judgment cannot rely on allegations alone, but must set forth evidence. And this case turns on the first and foremost prong, which is injury in fact. So we're not talking about some abstract, theoretical, amorphous type thing. We're talking about a real injury. And the court says, look, it's easy to make a mistake when looking at this. There's a difference between failing to establish the elements of a cause of action and failing to show an Article 3 injury. So a cause of action would be, for example, we've talked about this in the Fair Debt Collection Practices Act. It would be, hey, I'm a consumer. This is a consumer debt. I'm dealing with a debt collector who violated a provision of the Fair Debt Collection Practices Act. Well, those are your elements for a Fair Debt Collection Practices Act. And if you fail in proving one of those, you lose, but that's not a standing issue. And that's what the court points out here. One is a failure of proof. The other is a failure of jurisdiction. And there is overlap, but they're not the same. So in this particular case, it's a little bit different Fair Credit Reporting Act case. We're not saying there's false credit information, I disputed, it didn't get fixed. We're saying that I pulled my credit report and it did not have the necessary information. So here, the court says there's really three elements to prove this cause of action. This is different than jurisdiction. So number one, there's a duty. Consumer must disclose all information in the file. Number two, a breach of that duty. So the credit reporting agency, Telecheck's got to give me everything. They did not do it. And then I can get damages $100 to $1,000 for each willful violation. Now, because this was brought as a class action, even though I haven't read the complaint, I just know from doing class actions, the consumer would not have asked for actual damages because that sort of gets rid of, in most cases, a class action. Instead, you do statutory, which is each person can get $100 to $1,000. And you would do this because maybe there's 100,000 people or 1 million people affected by this. And so, the damages add up very quickly. So the court says, look, in one way, you don't have a problem. So you went beyond mere allegations and you provided proof of each required element. And it says, if he provided evidence checking each of those boxes, so again, these three elements listed up here, duty, breach of duty, and damages, that satisfies the requirement, and he's good, except we have to look at standing. Does Congress have the authority to label this violation of a statutory duty an Article 3, again, that's Constitution, Article 3 of the Constitution, injury when it comes to Huff? And we come back to this, we've talked about it a bunch, Spokio. There is no such thing as anything hurts so long as Congress says it hurts theory of Article 3 injury. All right, so the court says there are three ways that he could satisfy this idea of standing, this idea of an injury. So number one would be the statutory violation created an injury in fact as applied to him because it actually injured him. Then number two is the statutory violation did not injure him in a traditional way, but the risk of injury was so imminent that it satisfies Article 3. And then number three, it didn't create an injury, but Congress had the authority to say this is an injury in view of its identification of meaningful risk of harm in this area. So now they're going to take them one at a time. So let's look at number one. So an actual injury. And they just say it does not satisfy. He does not allege, much less prove, harm in the flesh and blood or dollars and cents sense of the term. He doesn't say it caused a declined check. He doesn't suggest that he wasted time or suffered emotional distress. This is really critical. In a non-class action case, typically when there's violation of consumer protection type law, FDCPA, FCRA, whatever it might be, you would allege emotional distress. And they're saying, well, he didn't do that here. And he does not say, if I had gotten all the information, then I would have done something with it. And instead, he says, did not have any effect on him. So number one is out. So remember up here, they say there are three ways. Well, number one is gone. How about number two? This is the one that says, it didn't actually hurt me, but there was an imminent risk of harm. And they say, nope, that doesn't work. As a matter of fact, it's the opposite. And there's just no danger that he would have a check declined. And it says a material risk of harm may establish standing. And this is some of the language from a case. Threatened injury must be certainly impending to constitute injury, in fact. And they say the idea that an incomplete disclosure would cause you to suffer a check decline, and that's what the court's limiting it here to. I'm not sure that that's the correct way to look at it, but that's what the court's doing here, is saying the only sort of harm could be a check decline. They say it's highly speculative. For the accounts were you last used, 2008, 2010, here we are in 2019. Nobody's going to write a bad check on them today. It says one of the other linked accounts was personal account, so you can't blame Telecheck's non-disclosure if he bounced a check on it. And then it's his wife as the other one. It says, this is sort of the logic or the chain that the majority opinion's building here. His wife would have to bounce check with Telecheck merchant. Merchant had to report the debt to Telecheck. Wife would have to leave the debt unresolved, and Huff would have to try to use Telecheck merchant while presenting his driver's license. It says the odds of that happening are remote. I'm not sure how they figure out that that's remote or not, but that's what they say. And then they say, in the 5 years since he requested his file, he's not had a check decline. So the court says, it's not, is there some risk of a check decline, but what additional risk comes from the non-disclosure of the information. And so stated another way, the majority opinion says we have to ask about the difference between what he would have done and what he did with the report. And there's no evidence of that. So they say full disclosure would not have reduced the risk. And it says, now that he has all the information, any remaining risk of check decline flows from his failure to delink the account. So in other words, he could have contacted Telecheck and said, let's unlink some of these accounts. So again, a little bit different writing style. Don't forget one last point. Telecheck alleviated any risk of harm by including the linked data disclaimer, instructed him to call. Had he done so, he could have learned which accounts linked him to, were any of those by mistake, and asked them to delete the appropriate accounts. There are appropriate links. Now, either the court is assuming this or this came out in the discovery that he could have done this. And then the court says there are times when depriving somebody of the information can be enough, but not here. And they say because he enabled, indeed encouraged Huff to access all the information, its failure to disclose the information created only a negligible risk. Now, the court will say later on that this is tough kind of figuring out all this stuff here, but they seem very confident, the majority opinion about this. Well, how about number three? Number three is basically, can Congress just say, look, if the defendant violates this law, that is enough to establish an injury. So a statutory violation can create a procedural or intangible injury. And he says that violated the FCRA. And the FCRA, the Consumer Reporting Agency, has to disclose all information. And he provided evidence that they didn't do it, and that's enough. And the court says, well, you're right and you're wrong. So let's look at when he is right here. It says intangible injuries, get that to highlight here, premised on statutory violations in some cases have satisfied this injury in fact requirement. So how do they figure that out? Well, they look at historical practice, they look at the judgment of Congress to see. And they point out the judgment is important. Judgment of Congress is important. And so when Congress confers a procedural right to protect a concrete interest, a violation of that right may establish the injury in fact. So he's right about that. But then they say he's wrong. Well, what's he wrong? That Congress, their ability has no limits. So it's left up to their imagination. And you say, well, why can't Congress just decide this? And they say separation of powers. Remember, you've got the executive branch, the legislative branch, the judicial branch. Separation of powers considerations preserve an outer limit on that authority. And then the court says if a claimant has not suffered a genuine harm or risk of harm, federal court has no business entertaining his lawsuit. Now, I think that's a little bit of an extreme statement because Congress can say this is a harm. And so it's a little bit of semantics here. Is the court saying in this highlighted sentence that there was no harm and no matter what Congress says, you can't change that fact? Or are they saying if Congress gave us more detail, then we would decide that there was harm? So the next sentence, Congress cannot conjure standing by declaring something harmful that is not by saying anything causes injury because the legislature says it causes injury. And they say there's a difference between injury in law and injury in fact. Otherwise, Congress could create injuries in law that require federal courts to issue advisory opinion. I keep mentioning this about advisory opinions. Advisory opinion would be like, imagine a senator goes to a federal court and says, I'm thinking about passing a bill. And I think the president will sign it. And it does X, Y, and Z. Can you tell me before it gets passed whether or not that is constitutional? Well, then that would be asking a federal judge who has no case before her to give this opinion on where she goes, I think that would violate the Constitution. Or no, that would be totally fine. That's not how the courts work. They wait till there's an actual case. You've got two parties that are fighting. And that's when the judge steps in and gives an opinion. Okay, but not ahead of time. And that's just the way that our courts are set up. So you can see the majority opinion is very focused on that here. And here's where they get a little bit colorful in their language. So they say, tricky legal problems, a border between what Congress may do and what it may not do remains elusive. And then the Maginot line. So this is a historical reference. If you remember in World War I, you had this trench warfare between the Allies and the Germans where both sides are just fighting over, a couple hundred yards of dirt, so to speak. Well, after World War I, the French built this elaborate fortification system. And they said, we'll never let the Germans come through again. Well, they felt very secure in that, but there was a major flaw in it, and the Germans just poured right through the flaw and never really attacked all these great fortifications. And so it provided the illusion of security. And so that's what the court's trying to conjure that picture here. And they say, but that's only because federal courts have frequently allowed Congress to create intangible injuries in the first place. And they say, still, we have to preserve a line. So even though they recognize this reference to the Maginot line, that it's not really that effective, they say we have to preserve a line, some line, else Congress becomes the author of the limitations of its own power, problem greater magnitude. This Marbury versus Madison is sort of the famous U.S. Supreme Court case that says Congress can review acts of Congress I may have said that wrong, that the federal courts can review acts of Congress and deem them to be unconstitutional. And they say, going back to our case here, it falls on the wrong side of the line. And so look at Spokio. We've talked about that before. That was a Fair Credit Reporting Act case where the information came back incorrect when somebody pulled their report. And the U.S. Supreme Court said, well, just because there's something wrong in your report does not necessarily mean there's a concrete harm if there's no consequence. And they said maybe an incorrect zip code. That's been pretty heavily criticized because actually a wrong zip code can cause you harm. You're trying to get a security clearance, get approved for a job, and your zip code is wrong. And that can trigger a red flag. But this was one of our Supreme Court justices just kind of speaking off top of his or her head saying, well, it's not like it's just a wrong zip code. I mean, how could that harm me? Well, it actually can. That's not what Spokio was about. But anyway, that's what the court's referencing here. And then they look at a Fair Debt Collection Practices Act case, and they say, here's a letter to a lawyer of two debtors allegedly violated the FDCPA, failed to disclose it came from a debt collector. We said the debtors lack standing because there can't be any negative consequences. So this is why sometimes we have pointed out that if you're dealing with a debt collector and you're not in a lawsuit, sometimes you actually lose some rights if you have lawyers representing you. Now, we'll cover this case in detail. I don't remember the specific case, but oftentimes courts will say, if a debt collector lies to your lawyer, you can't sue for that because we expect your lawyer to basically be the police officer for the debt collector and make sure they stay in line, which is silly to me. But whatever the details of this, they said, that wasn't good enough to create standing. So here's another case under the Fair Credit Reporting Act. And so the consumer requested file. The report did not contain the correct source of information about one of his debts. And it did give the creditor and some information, and the court said, that didn't cause you harm. So you can't stay in federal court on this. And I hope you're seeing a pattern that defendants, by attacking virtually every federal consumer protection case, attacking it on basis of standing, they do get some of these decisions where they're successful. And so you've got to understand that before you bring a case, and that's why I would suggest filing in state court and letting it get removed to federal court. And then if the defendant attacks it there, you don't lose your case, you just go back to state court. And this court says all three of those cases we look at lead to the same destination. It did not have any adverse consequences, Telecheck not giving you your full thing. So let's go to behind all this stands an important principle. And they say, and I don't know if he's trying to be funny here, the judge, or not, but although Congress wields broad authority to define it does not have a blank check, as we're looking at a Telecheck check service here. It says any other conclusion would give Congress the final say, and that goes against the principles as we established the federal government here. So the horizontal separation of powers prevents Congress from flattening Article 3's limitations by defining harmless procedural violations as injuries in fact. And I think the opinion here recognizes, well, it sounds like we're saying Congress can't do anything. And they say, no, Congress still has a whole bunch of power. They just have to explain themselves. And in the absence of an explanation of how a seemingly, I think that's important, seemingly harmless procedural violation constitutes a real injury, we're left with a canyon-sized gap between their authority and the problem it seeks to resolve. And so they say, well, let's look at a couple of examples here. So this Lopez case from 1995, Supreme Court invalidated a federal law banning firearms within a certain distance of school. And they say, no, you overstepped your bounds. And one reason is the court said you haven't explained how this affects interstate commerce. So just as a quick side note, basically the reason that Congress can pass all these laws that affect all of our lives is the Constitution says they can regulate laws affecting interstate commerce, which sounds like it would just be, like I ship something from Alabama to Florida. But the court has very broadly interpreted what interstate commerce is. And so almost anything affects interstate commerce. But the court in this Lopez case says, well, you didn't explain how it affects it. Well, Congress listened to that and they amended the statute. And they include interstate jurisdictional prerequisite for prosecution. And so after that, courts have upheld it. So the point that the Huff majority opinion is making here is that courts can say, hey, Congress, you didn't say enough, you didn't explain enough. And Congress has the ability to go back and sort of correct that. And then they say, here's a law, the Religious Freedom Restoration Act. And the court said, U.S. Supreme Court 1997 invalidated that, said it exceeded Congress enforcement power under Section 5 of the 14th Amendment. And one reason is it failed to provide legislative record documenting any pattern of violations that would justify extending. Well, after that decision, Congress basically modified the law, cut it back a little bit, and gave the record or the legislative support for why this law was needed. And so Huff points out, well, since then, challenges have been rejected. So again, I think recognizing that its opinion could be taken the wrong way, the majority opinion says, look, Congress does not have to make findings of fact. They don't have to say, well, here's a problem. If you remember from our videos where we go through the FDCPA, how does the FDCPA starts off? It says, Congress finds that there's been all this terrible abuse and it causes all these problems by abusive debt collectors. And so it lays out why the law is necessary. So this opinion saying, well, you don't have to do that. You're not an administrative agency. You don't have to give your reasoning. But they're saying that's helpful. And even if you give your reasoning, that does not necessarily mean that you can create Article 3 standing just by a violation. So in the borderlands of congressional power to define intangible injuries, a vexing area under any circumstance, guidance about the ills a statute is meant to remedy can instruct and guide. So they're saying to Congress, look, if you get close to the edge where it's kind of questionable, it would sure help you if you would provide guidance about here's what we're trying to fix with this statute. And the court, the majority opinion, says they haven't given us any guidance. I think we'll see the dissenting opinion says you're absolutely wrong about that. And so the majority opinion says, well, if you'd explained why an incomplete disclosure hurts somebody, then we might have a difference of opinion here. But they say, we don't see how a technical violation with no consequence or real risk of injury, that shows that you've actually been injured. And so they say, we're throwing you out. But then they say, well, let's look at the plaintiff's two arguments here. Says, number one, failure to get all this information robbed him of his right to monitor his file, which prevented him from disputing the accuracy of the links. And so the argument is he didn't know about this and no way to delink it. And they say, well, let's assume that they wrongfully linked your accounts. They never made a difference. Okay? So you never got turned down. Now, again, this is sort of a bizarre result to me because let's take it in the normal credit reporting context, having your mortgage and stuff on there. Well, what if there's a false entry on your credit report, but you don't have a credit turned down? And almost all judges say you do not have to have a credit turned down to sue under the Fair Credit Reporting Act. Well, I can guarantee you that companies that are sued under the Fair Credit Reporting Act are going to take this highlighted language and say, see, it didn't cause you a credit turn down, so what's the big deal? There's no problem here. And now I think they would say, well, no, we're talking about if you just didn't get a full disclosure. But the point is they're rejecting his argument, and I think their language is a little bit loose here. And then they say he never did anything with this information, indicating he wouldn't have done anything even if he had received it earlier. Again, I think that's a little suspect reasoning, but that's their argument. And they go to this 1989 case and 1998 case, and they say in those cases, depriving somebody of information can provide standing because you would have used that information to participate in the political process. So here, in contrast, Telecheck's incomplete report had no effect on Huff or his future conduct. Again, I'm wondering how they know that. And, you could just as easily argue, well, if you had gotten this information, you really wouldn't have done anything in the political arena with this. But anyway, this is how the majority is ruled here. So the Act never attempts to show how a technical impairment of a consumer's ability to monitor a credit report that carries no consequences rises to the level of Article 3 injury. And then here's another argument, this Macy versus GC Services. The argument shows that the risk of a check decline created by non-disclosure establishes standing. And they say, well, wait a minute. That case involves the FDCPA, Fair Debt Collection Practices Act. So they got a letter saying your credit card account's been referred to the company for collection. You could dispute in 30 days, but it failed to say the dispute had to be in writing. And they say this violated 1692 GA. If you remember from our FDCPA videos, this is what's called the debt validation section. And so the consumer sued, and the Sixth Circuit, same court that's written this Huff opinion, says we found standing because the failure to include the words in writing create a material risk that might forfeit other protections. Well, how is that? So they point out, in enacting the FDCPA, Congress sought to curb abusive debt collection activities. And in finding the non-disclosure posed a material risk of harm, we observed that a written dispute triggered other statutory protections. So if you remember, if you do a written dispute within 30 days of getting the debt validation notice, that requires the debt collector to verify the debt. The debt collector cannot collect on the debt until they complete that verification. An oral dispute would forfeit those protections, and because Congress tied the writing requirement to protections, that's a material risk of harm. And they say, by way of contrast, the Fair Credit Reporting Act does not contain such interlocking statutory protections. And it says it does not provide a shield from imminent economic harm the same way as the FDCPA. The main target or goal is dissemination of inaccurate and harmful information. And then they say, again, I think this is a conclusion the majority is drawing, but in any event, they say the non-disclosure never harmed and it did not create a material risk, so he suffered no injury in fact. And then they say this comes down to a difference in how Congress exercised its power. In Macy, so remember Macy's this one up here with the, they didn't say you had to dispute in writing. And truthfully, you don't have to dispute in writing. You can dispute verbally, but that 1692G notice should say in writing. And they say in Macy, that FDCPA case, Congress did not trespass on Article 3 because statutory violation was closely connected to real economic harm and thus amounted to injury. In fact, in this case, Congress crossed the line. It is not shown how a deprivation of information that neither holds consequences for the consumer nor imposes a real risk of harm creates an injury. And since they don't have that, they say, we have only Congress's say-so, and that does not suffice as long as federal courts preserve structural boundaries. So, again, I think the majority opinion is kind of pushing back a little bit, saying, hey, don't criticize us. We're just doing our jobs of keeping Congress in check here. And this happens when you have dissenting opinions. Oftentimes the majority will say, well, now here's what the dissenting opinion is saying about us, and it's wrong. So dissent claims we have declared the FCRA unconstitutional as exceeding Congress' power to provide judicial remedy. That overstates. And then they say, just as no one can obtain an advisory opinion about the meaning of this law or any other, no one can enforce this law or any other without a concrete Article 3 injury in fact. So again, imagine if, let's say, Equifax went to a federal judge and said, now, nobody sued us. We just want you to tell us, what do we have to do to comply with a certain section of the FCRA? And then the federal judge writes an opinion on that. Well, that would be an advisory opinion, and we don't allow that. And then they say, I think this is a pretty weak argument, but even in this case, our decision does not mean the alleged violations must escape scrutiny. The Federal Trade Commission and other agencies can enforce compliance. And I think the other thing to say is, and the court doesn't say this because most people don't talk about this, but you could sue them in state court. And state courts don't necessarily have the same Article 3 requirement. Now, it depends on the constitution of the state, but most states just say, you can come into our court. And the state judges might view this differently than this federal court has viewed it. And then they say, let's think about something else. And in the Spokio decision, that's the original Supreme Court decision, it kind of started us down this path. Justice Clarence Thomas pointed out in what's called a concurring opinion. So he agrees with the result, and sometimes they say, I concur in result only. So it's like, guys, I think you got the right decision, but you got there through the wrong path. And so he says that you're really looking at a distinction between private and public rights. So if we're talking about private rights, so these are duties owed to plaintiffs as individuals, a bare statutory violation may be enough. But when you're talking about things that affect the community as a whole, you've got to have some individual harm. And we may look at the Spokio opinion in a later video, and his full explanation, I think, makes more sense. Obviously here they're just trying to quickly summarize it. And the opinion here says, this might need to be looked at to give us some guidance, because this is a very challenging area. And then they say, but this raises some questions, because what Justice Thomas was mainly talking about, as I remember it, is let's look back in history, what's called the common law. So not really dealing with statutory type violations. And so what he does is, let's look at things that are like the statutory violation. So what would be a common law? And these are things that have been around since like the time of, back in England and when we started our country. So you'd have negligence and wantonness and invasion of privacy and all those types of things. He says, well, find some parallel to it and see if that was enough to create standing. And they say, whatever is true of Congress' power to create standing by statute would seem to hold for state legislatures as well, posing another threat. And then they go on asking some questions. What of laws that use nominally private rights as a way of commissioning private attorneys general to enforce public regulatory schemes, and that has no 18th century errors? What they're talking about is like the FDCPA. What we said in the FDCPA is the government doesn't have enough resources to stop the abuse of debt collectors, so it wants citizens to go out and file suit. And so it's the concept of like being a private attorney general. You are sort of doing the work of the government when you sue abusive debt collectors, abusive credit reporting agencies, and that takes the burden off the federal government of having to file all these lawsuits. And so anyway, they ultimately say, well, be that as it may, with this sort of theory of Justice Thomas, we just rule that you lose. So here's Judge White dissenting. And we saw this quote in the majority opinion. It says it's unconstitutional. And This judge completely disagrees with that, and here's why. Number one, Congress conferred on consumers the right to request their entire file to protect their interest in having only accurate information reported. And number two, failure to provide the entire file created a material risk that inaccurate information be reported about him, and he would face a check decline. So you can see nobody disagrees about the facts here. It's just how do you interpret them. So here the dissenting judge is saying, look, Congress said you're supposed to get your entire file to protect yourself. You didn't get the entire file. Therefore, you have the right to be in federal court. And the majority is saying, no, that's not nearly enough. And so you'll see this court cites to that Macy case, the Fair Debt Collection Practices Act. This court recently, 2018, held a violation of procedural right is sufficient. Congress conferred the right to protect interest, and there's a material risk of real harm. And unlike the majority opinion, the dissenting opinion says both of those are met here. So let's start off. It says, get that to highlight. Congress conferred on consumers the right to obtain their full file in not having false credit information. And so this is what Spokio said. Congress plainly sought to curb the dissemination of false information by adopting procedures designed to decrease that risk. Well, how are you going to decrease that risk? Well, one is you have the reporting agency be required to divulge the information in its file, not to have secret files or they're only going to give you a little portion. No, get the whole thing. And then here's another quote. And by the way, that quote is from 1987, the 11th Circuit, which is where I practice. So this covers the states of Georgia, Florida, and Alabama. And so here's a quote. Purpose of the FCRA is provide the consumer with the opportunity to dispute the accuracy of information. Well, it kind of makes sense. For you to know what's inaccurate, don't you have to know what's in your file? So that's the argument here. So once the consumer identifies allegedly inaccurate information, there's a detailed grievance procedure. So we've talked about that before. That's where you dispute directly to the credit bureaus. And you can copy the dispute to the furnisher, whoever provided or furnished the information, but you got to go to the credit bureaus. And then the credit bureaus will investigate. They'll go to the furnisher of the information. So you guys investigate. And so that's the detailed grievance process or procedure. So in short, a primary purpose is to allow consumers to identify inaccurate information and correct this. Thus, Congress conferred on consumers the procedural right to receive their file upon request to reduce the concrete risk that inaccurate information about them would be disclosed. In other words, Congress has recognized there's a whole bunch of errors. Well, how are you going to figure out those errors? Well, you look at your credit report. Well, how do you know your credit report will contain the errors that are actually in your file? Well, you got to see the whole file. So here the judge is saying, look, the first argument is met. Remember up here, Congress conferred the procedural right to protect concrete interest. Now, second, the violation of that procedural right presents a material risk of real harm. So here we go with this. And this is just a conclusion. Just say it does create a material risk. And then now the judge is going to explain this. Unbeknownst to Huff, Telecheck linked his driver's license with bank accounts that were not his. And when he exercised his right to receive his file, they failed to disclose those. And so he was unable to use the grievance process to correct that information. So let's imagine this in a normal credit report context. And you've got a Discover card, a Chase card, and those are yours. And those are disclosed in your file. But then undisclosed to you is a Regions Bank mortgage. Well, if it's not on your file, how do you know to dispute it? And if it's not in your file, how can you send a dispute to Equifax, Experian, TransUnion saying, I dispute the Regions mortgage account, which even though it's not listed on my file, somehow I secretly know that it's actually in my file. So the dissenting judge, I think, is making a great point here. So consequently, was at risk of harm if one of those accounts developed a debt. Remember, a debt would be like you bounced a check and owed money. And then he presents his driver's license while paying by check. And now, remember how the majority opinion said, well, now the dissent says X, Y, and Z, and the specific thing was FCRA is unconstitutional. We think she overstates that. Well, here, the dissenting opinion is doing kind of the same thing. The majority disagrees faced a material risk, distinguishing Macy. FCRA does not contain such interlocking statutory protection. And the dissenting judge says it does. It interlocks the consumer's right to file with his ability to correct inaccurate information through the procedure. And it says it would make sense that Congress would use different procedural protections because there are different purposes of the Fair Credit Reporting Act and the Fair Debt Collection Practices Act. So the method by which Congress chose to protect your interest under the FCRA is a function of the harm he faced. And so let's kind of ride this thought out. Just as notifying a debtor the actions required to preserve his rights minimizes the risk of abusive debt collection practices, that would be the FDCPA, enabling a consumer well situated to detect his own inaccurate information to review his file minimizes the risk of a disclosure of an inaccurate credit report. And then the judge says, by providing the incomplete file, they deprived Huff of the information necessary to dispute the erroneously linked accounts and thus create a material risk if one of those developed a debt. False information be reported, check would be declined. It says it appears the majority's real quarrel is with Macy itself. The majority would prefer a rule that requires the plaintiff to show actual harm. So obviously the majority didn't say that directly because, let me take this one step back. So each of the appellate courts, we've got the First Circuit Court of Appeals, Second Circuit, all the way to the 11th, and there's a couple more. They decide opinions in panels of judges. Those are 3-judge panels. But there might be 20 judges in the whole circuit. Well, if one panel, so let's say that has Bob and Sue and Jack as the judges, they decide a case one way, and then 3 of us are on another panel, we can't overrule that first case. We don't have that authority within the circuit. Only when all the judges get together, it's called being en banc, so it's, there's like 20 or 30 judges. Only they can say we're overruling one of our prior cases. So what the dissent is saying here is that, well, really the majority doesn't like Macy, the Fair Debt Collection Practices Act case, but it can't overrule it. And so it's kind of trying to really limit it to just the FDCPA and not allow it to naturally flow to the FCRA. And then the dissent is going to look at some of these other cases here. Do not support the conclusion there's no material risk of harm. Spokio, that's a U.S. Supreme Court case. Example of incorrect zip code suggests a lower bar than the bar set by the majority here. And the court says, erroneously linking identifying information presents a far greater risk of harm than incorrect zip code. It's hard to imagine the risk of harm from an incorrect zip code, but like we talked about, there actually is. I mean, it could mess you up on a security clearance, on a job. It can trigger a red flag in a loan application because you say your zip code is, 35203, but your credit report says it's 35147. And that raises a question, like what's going on here? But anyway, the dissenting opinion says the risk of linking individual to accounts not owned by him is apparent. Telecheck effectively tied his creditworthiness to another consumer's, and he faced the risk of erroneously reporting a negative credit assessment solely because of that. And then this Hagee case is materially different. Creditor failed to provide required disclosure in which the creditor discharged a debt. Thus, unlike in this case, a violation presented no risk because the creditor's letter to debtors was good news. So we'll look at that case and see exactly what they're talking about. And then they look at this Experian case, and the dissenting says you missed it for 2 reasons. And one is it's this different standard of injuries. And so it says a plaintiff, let's get the highlighting here, lacks standing unless denied access to information required to be disclosed, and he suffers the type of injury that Congress was trying to prevent. It says that standard is different from the one based on Spokio articulated by Macy because it requires the consumer suffer a harm rather than simply face the risk of harm. So notice up here it says he suffers the type of harm as opposed to just the risk. And then second reason is before the court even considered whether the violation adversely affected the conduct, it concluded the harm the consumer claimed is not the type of harm Congress sought to prevent when it enacted the FCRA. And we get this. Fair to identify either a common law analog. So in other words, something that we could look at in the common law that's similar, doesn't have to be identical, but similar to what the violation of the statute is. Or a harm Congress sought to prevent, the consumer is left with statutory violation divorced from any real-world effect. Here, Huff claims a risk to concrete interest Congress sought to prevent, inaccurate credit report based on bank accounts that are not his. And then she says, look, the majority is wrong by saying Congress should have explained itself. And says, well, even if that was necessary, and I think the dissenting judge says it's not necessary, Congress did explain. And you'll notice, quoting from the majority, the canyon-sized gap between Congress authority and problem seeks to resolve. And it says Congress closely tied the right of disclosure of one's entire file to the legitimate purpose of preventing the report of inaccurate information. Congress established a disclosure requirement to enable a consumer correct inaccurate information in his or her file, thus reducing the risk of inaccurate credit report. You see this common theme. The dissent, I think correctly, is just hammering home on the whole purpose of the reason you have the right to obtain your credit report is because you're in the best position to fix it. You know better than anybody else whether there's something inaccurate in your credit report. Well, you can only fix it if you know what it says. Kind of hard to fix something that you don't know exists. And then it says the majority supplies little basis for faulting Congress for failing to connect the procedural violation with risk of harm. And Spokio doesn't do that. And then remember these two decisions, the 95 decision, 97, I think that was a firearms and that was a religious freedom. And it says, neither Lopez nor City of Bourne involved limits on Congress' power to provide judicial remedy for statutory harms under Article 3. And so I dissent. So that's the case. And I know it's a little bit tedious going through that, but I just want you to see, first of all, this raging battle that's going on over standing and injury. And then also to see a case where you've got the two judges that wrote the majority opinion, they absolutely believe what they said is right. The judge that wrote the dissenting opinion absolutely believes what she wrote is right. And so, oftentimes, particularly in this political environment, anybody that takes a contrary position, we sort of give bad motives to, right? Like, you're crazy if you take that position. Well, it shows reasonable people can take different positions. And just as maybe this will be interesting for you, most cases that make it to the U.S. Supreme Court make it there because these different circuits, so this is the Sixth Circuit, they disagree. So you might have, let's say, I'm not going to use specific examples, but let's say 4 of the circuits say the law is X, and 3 of the circuits say, no, the law is not X, and then the other circuits haven't spoken on it. Well, the U.S. Supreme Court may take that case up to what's called resolve the conflict among the circuits. So you've got all these judges who honestly, reasonably believe that the answer is X, and all these judges that are just as smart, just as reasonable, they go the other way. And then the U.S. Supreme Court case is going to tell us who's right. But sometimes within that case, it may be, there's 9 justices, it may be 5 justices say the answer is this way, and 4 say absolutely not, it's the other way. And so again, it goes back to when we're looking at the law, it's hard to have just absolute 100% concrete answers because you can see how judges disagree pretty strongly. And, this is a pretty civil disagreement here between these judges. There are some opinions where the judges are really taking shots at each other. And, I mean, you can tell it's really kind of, I won't say personal, but they just feel incredibly passionate about the position they take. So anyway, hope that this is helpful to you, and feel free to leave any comments below, and I'll catch you guys in the next video. Thanks a lot. Bye.